What's going on, world? My name is Kaleem Akhenaten. I just want to build on some things, just as a matter of public importance, as a matter of public record. You know what I mean? Like, a lot of us have crafts that, we do and we get paid for, and it's how we put food on the table. You know what I mean? It's those things that we enjoy doing. So it's not really looked at as work, but as enjoying life and making the most of your skills, harnessing them to, be able to support yourself as well as your family. Like I got a multitude of homies. They into construction, real estate, other things, some of them in the music, but they're able to make do with their craft. They're able to get paid for their craft. My craft is the law. I dabble in the legal field. I don't dabble, I perform in the legal field. You know what I mean? That's where my uniqueness and my talents lie. You know what I mean? So, like any other craft, I should get paid for my craft. However, there is a difference in the craft that I chose to make a living with, and that is that in the judicial system, fairness is a thing mostly paid for and mostly dispersed to those who are non-white, non-European. So when you dealing in a matter as a pro se like myself, the term meaning without acting counsel, without a lawyer, you know what I mean, or without an attorney. So that only puts the spotlight on you that much more. And me being a black man, a young black man who hasn't gone to school and obtained that legal degree that says that I went to school and learned what it is that I'm doing, I get a lot of backlash for that. You know what I mean? I'm looked down upon as not knowing what I'm doing, or as people believing that I must be out of my mind to step into a courtroom without an attorney present or without counsel guiding my matter. However, all of us don't need attorneys. Some of us are gifted in understanding and comprehending the law. You know what I mean? And the judicial system has its pros and it has its cons. The pros are there are monetary awards that one can obtain in, winning a case, a civil case. There are benefits in winning a criminal matter. I mean, there's benefits, in the judicial system all around the board. What I want to get into is a matter that I have in federal court right now, dealing with a wrongful termination that I underwent back in 2015 with this company named EFFLUENT Retrieval Services. My matter is actually called Reinard Smith versus EFFLUENT Retrieval Services, ETAL, meaning in others. And the other is the owner of EFFLUENT Retrieval Services, John Beagle. He is the one who terminated me, based on some discriminatory practices, which was racist at heart, and retaliation for my filing an internal complaint, addressing days that I didn't get paid in which I worked. And all I was trying to do was bring to his attention that, these days that I didn't work and these days that I did work but didn't get paid need to be handled. I didn't come in like a bully or anything, just trying to get my just due, that's all. So we wind up having to go to federal court because, like most employers, this guy's arrogant. And also what sent us in the federal court is that he denied my unemployment compensation. He told them that I was an independent contractor, which was a lie. And it started the motion of litigation. So I wound up challenging him in the unemployment forum as well as in a federal court. So the unemployment forum we're finished, and in that forum he lost. In the federal court forum I lost, but presently I am on appeal, seeking to get the judgment of the district court reversed. And it's a reason that the district court should be reversed. It's multiple reasons actually, but the matter in itself is just showing how pro se litigants don't get fair treatment, especially being a black person. It's documented throughout history how we have faced injustice in the courtrooms. How innocent brothers and sisters have, been incarcerated under false pretenses, manufactured evidence. I even have one of those cases, and I will present it to you, on another note and at another time. This segment here is strictly for my civil case that's in court right now. I will be addressing a lot of things because there's a lot of information to give. I also will be addressing the UCC, Uniform Commercial Code. Many people say it don't work. Southern Poverty Law Center says it doesn't work. I have a document that absolutely refutes anything they say and show that it does work. And I'm willing to challenge anybody, even if we got to put up money to show that the Uniform Commercial Code does work in criminal matters as well as civil matters, and any other matters. But back to the issue at hand, my wrongful termination matter against Effluent Retrieval Services, Inc. You can find it. It is called Reinard Smith versus Effluent Retrieval Services. It's simple. Like, when you're trying to establish someone as an independent contractor, there are things that you just have to do. Matter of fact, I want to share something else. I want you to know that I'm in school. I'm in college. I'm in Community College of Philadelphia. This is my Jenkins Law Library membership. But my major is paralegal. My aim is to get my license to practice law so that I can be a voice for, the oppressed in court. You know what I mean? Because they need a voice. They need somebody who's going to stand up for them, who's not going to jerk them around or, you know, half step or, you know, just not do a good job with their case. You know, this is why I took up, you know, the arms to step in and finally, you know, go ahead and strive to get my license to practice law. Because when I first appeared with my education and understanding and knowledge of the law, you know, I wasn't about getting a license to practice law. You know, that just was unheard. I wasn't with none of that, and it was a reason for it. But now, you know, I'm on a different platform. I'm in a different train of thought. I'm a different perspective right now, and you know, it's like I'm seeing things and I'm like, wow, I could have did this back then and I would be established right now. But, you know, like they say, it's never too late. So here I am right now. Now, what I want to get into is some of these documents, you know, just to do some things like, you know, my paralegal course, I actually failed it, but it wasn't because I didn't know the material. It was because I wasn't meeting the deadlines when it was time to turn in my assignments, you know, and that's understandable. But at the same time, you know, what was really going on was I was fighting my legal matter in federal court as well as in the unemployment field. So, you know, the instructor who I had for legal research and writing, instructor Linda Hibbs, her thing was, you know, she wanted us to meet our deadlines. So this is why she wouldn't give us an extension on homework and things of that matter, because she wanted us to meet the deadlines. But my thing was, I'm not just doing this for homework. I'm meeting deadlines in real life. Like, I'm getting my motions filed in real life. I'm getting all my legal work filed on time in real life. So that mechanism that she was using to get us, you know, prone to submitting our legal works on time, I was already doing it in real life. So, you know, that didn't help me. You know, my thing was, when I went to all my instructors, you know, they gave me an extension of time to get things completed. She was the only instructor who didn't give me time to get things completed. You know, and it's sad because, you know, you're getting us ready for the legal world, but in the real world, extensions are granted. And that's just the truth of the matter. So why in class would not extensions be granted? I mean, when we dealing with reality, you have to look and we have to see. I don't want to get too heavy into that, but I remember one time I had a submission of an assignment that she gave us, and she told me that part of my assignment was wrong because of how I cited the case. You know, so I went in the book and it says right here, you know, use the following public domain citation format. And I use this format right here, PA Super. I used that format. She told me I was supposed to write the whole complete thing. PA Super CT, meaning PA Superior Court, excuse me. However, as you can see, this citation is just as equivalent as that citation. So these are some of the technicalities that I was going through in legal research and writing, you know, and it was her attitude of not wanting anybody to come across as if they knew some things before she taught those things to the person. So her thing was simply like, you know, you can't know nothing, you know what I mean, until I teach it. And, you know, I just didn't agree with that. I didn't agree with that approach, you know, given the fact that I have extensive training in the legal field, you know what I mean? Not just legal training, on hands legal training. Like, I've been in courtrooms, I've done jury trials on my own without an attorney, you know what I mean? I've cross-examined police officers on my own without an attorney. So, you know, I filed briefs, I filed motions, I've been up to the 3rd Circuit. I'm in the 3rd Circuit Court right now. I even filed a brief for the United States Supreme Court, or a writ of certiorari for the United States Supreme Court. So, you know, we're not going to talk about experience, you know what I mean, because I have that on-hands experience. So, you know, to me, I'm like, wow, I failed my paralegal class, but I know it wasn't because I didn't know the materials, you know what I mean? It was more of not meeting my deadlines for homework when I was meeting my deadlines in real life. So, you know, that's some of the stuff you got to go through, especially as a dominant male. You know, I'm a alpha male. You see what I'm saying? So a lot of people don't like alpha males. You know what I mean? Actually, there's a war right now against alpha males. The feminine male is being more recognized and more promoted than the alpha male or the dominant male. You know what I mean? So we can see, you know, why in school, you know, if I was to give an analogy of a legal case and my understanding and my perspective, that it would be shot down because they don't want the alpha male image to be promoted. So this is just part of, you know, the war on the alpha male right now, or, you know, should I say part of the war on the black man. You know what I mean? They don't want dominant black men in the society right now. They want passive men in society right now. But I know I'm getting a little off track, but, you know, these are some of the things that's going on that you must be made aware of. This is why I'm bringing this publicly to you. You know what I mean? Like, I got a whole file of information right here, like, dealing with my matter. I wanted to go into, you know, when he first answered my complaint. You know what I mean? And this is some of the things that he said. You know, the way he drafted this basically tells you that I was an employee, because he's making the assumption, he's making it to the point where, like right here, he says, admitted that plaintiff may have been paid for 1 day that week, denied that plaintiff was not paid for any days worked. This is not really what I wanted to get at. I wanted to get to his affirmative defenses, because that's where you can really tell what's going on, what he's saying. And right here, he says plaintiff claims are barred in whole or in part because defendants acted in good faith and with reasonable and probable cause based on the then existing circumstances. Again, plaintiff claims are barred in whole in part because an employer may not be found liable to an employee for injuries arising from the misconduct of the employee or other employees arising outside the scope of their employment. Right there, he tells you that he was an employer and I was an employee. He's saying that he shouldn't be penalized if I was stigmatized by another employee of his. You see what I'm saying? So right there, he tells you, you know, that he's an employer. He doesn't make any claims of that deal with an independent contractor in his affirmative defenses. So, you know, that there is says a lot within itself. You know, it's just that it's our job as the plaintiff to bring this stuff out, to bring this stuff to the forefront. You know, now the judge that's sitting on the matter, District Judge Gerald Patriot, basically he's against pro se proponents. He's against pro se litigants. He says he's not, but you could tell by his demeanor, by his whole thing, that he's against pro se litigants. And this is basically what's going on. This is what I want to prove and show, you know what I mean, that he was unfair, that he shouldn't have made the judgment that he rendered. He know it, I know it, the facts show it. This is a telephonic hearing that we had, telephone conference before Judge Patriot, which was on July 19th, 2016 at 2:03 p.m. But right here on page 4 of this transcript, this is the court talking. Before I discuss your motion, who is acting as your lawyer in this case? This is me talking. Mr. Patriot, I thought you were aware from the beginning, as I informed you, that I would be moving pro se. This is the court. Well, first of all, it's Judge Patriot, and this is me, Judge Patriot, the court. And second of all, your papers reveal that it's clear from your papers that they, particularly the discovery requests, that they have been drafted by, or that you have been advised by someone who is either a lawyer who has legal training. And my point in asking you the question is, if in fact you are being assisted by a lawyer, might it be possible for that person to enter his or her appearance in the case so that you can be formally represented by counsel, which would be helpful, I think, to everyone. This is me. So what I'm gathering is that I, as a pro se, am being at a disadvantage. The court. No, Mr. Smith, you're not gathering that. This is me again. Okay. This is text from page 5 of the transcript. So far I've read page 4 and page 5. This is more on page 5. This is me talking. Well, this is the court. Is there someone? This is me. No, I don't have anyone assisting me. The court. You drafted all these papers yourself with no assistance from an attorney or anyone with legal training? This is me. Yes, I drafted these papers myself. The court. Including the interrogatories? This is me. Including the interrogatories. The court. Okay, all right then. Well, let's take your disposition first. When are you available? This is me. Well, I didn't make the first deposition because I have recently enrolled in college for paralegal courses. This is page 6. This is the end of page 6 that I just read to you. Now, I'm going on to page 9. This is the court. Well, your motion is entitled Motion to Compel Better Answers to Your Interrogatories. This is me. Okay, so as a pro se, I don't get the liberal construction. I'm just questioning because it seems like when I come before this court, I'm always at a disadvantage. And I don't want to feel that way, and I don't want to perceive it that way, because first and foremost, I filed a motion to compel before the phone conference was even requested. And I don't feel like that. It's not that even that I feel I'm not getting anything from the court to say that this is a fair dealing, because just as you just said, you're not going to order deposition for the defendant to be present at a deposition that is needed as well for me to support my claims and interrogatories that I feel were never answered and that seemingly never were answered at all. The court is basically, you just ordered for the defendant, so I don't want to say that the court is being biased, but it seems like that's the nature of what is taking place. This is page 10. The court, Mr. Smith, me. I don't want to feel like that. The court, Mr. Smith, okay, I ordered your deposition to take place because that was the motion that was presented to me by Mr. Lentz. The other motion that is in front of me is your motion to compel better answers to Plaintiff Smith's interrogatories. All right, that's what I said. The court says that's what I'm dealing with. I can't control what you feel or what you perceive, but I can control, and what I will control are accusations of biasness. You are not to make such an accusation again. Do you understand me? This is the court talking. That's page 10. So I respond, Judge Patriot, I understand. This is, I'm going to go down further other pages, because I want you to see what's going on. As I said, you could tell that, he's not a fair player with pro se litigants. You know what I mean? It's ridiculous that pro se litigants have to jump the many hurdles that they have to jump. I'm not saying that all pro se litigants are adequate and know what they're talking about. I'm just talking about those who do know what they're talking about and are adequate. Now, I'm trying to get to in here where we talk about some other thing here. Okay, here's page 20. The court says, so you see, they answered your question. They made an objection, and then without waiving their objection, they answered your question by telling you that you were paid as a 1099 employee, which presumably you're aware of, and that as such. I said, no, I'm not. The court, as such, okay, well, this is me. Okay, well, okay, we'll leave it there because you're saying I'm aware of it, but that's something I'm not aware of. Because I'm trying to figure out what makes me presumably aware that I'm, being paid as a 1099 employee. You know what I mean? These are things he's just assuming, but the law doesn't really give you the room to assume that, to say that a person should, know that they're being paid as a 1099 employee. How can you know that if you're an employee? You know what I mean? And you're not an independent contractor. And again, on page 21, this is the court again. And you drafted that interrogatory yourself. This is me. I went and I said to myself, in drafting these interrogatories, like Judge Patriot, I'm doing my best here. I'm just feeling like it's a problem with me being a pro se, me taking a pro se status. The court, Mr. Smith, please stop that, okay? Just please, Mr. Smith, this is me. I want to, Mr. Judge Patriot, I want to. The court, Mr. Smith, stop talking. If anything, your interrogatories are better because they are drafted as though they have been drafted by a lawyer. Somewhere in there's a compliment for you, okay? Please stop whining and complaining about the fact that you're pro se. I know you're pro se. I'm not treating you any differently. I'm giving you a lot of time to walk through discovery issues and emotions so that I can resolve it for you, okay? Now, the thing is, actually earlier in this telephone conference, he said that he already resolved it. He already, reviewed it and made a determination. So why is he walking me through so he can resolve it now? These are the things that I'm talking about. You know what I mean? And then this is page 22 that I just read off of. I'm gonna read some more, page 22, and this is me. I mean, when I submitted the motion, I thought the court had already either reviewed it, but I mean, it's, and the court cut me off. Mr. Smith, I have reviewed it. I reviewed it, and I'm reviewing it again with you. This is what he says. He's reviewing it again with me. But my thing is, if you already reviewed it and made a determination, why do you have to review it again with me? It doesn't make sense. You know what I mean? And this is more stuff. You know what I mean? This is me on page 26. My objection to that is simply that misclassification is not a defense. The defendants are putting forth that they are able to put forth two alternative defenses. It doesn't classify as a defense when you misclassify somebody, is what I'm getting at, as well as the Unemployment Service Center is not a branch of the Federal Judicial Department, and that alternatively they allege defense for misclassification wouldn't be and should not be counted as a defense towards this matter here in court, because they have to take on two different functions. I want you to know another thing. Another technique and tactic that they use is they rewrite the transcript before it's officially transcribed. So, if you ever experience a delay in getting your transcripts, more than likely they're rewriting it to take something out and add something in so that they can't be discovered. I went through this multiple times, which I will get into in other segments, but this segment is simply dealing with Judge Patriot and Effluent Retrieval Services Incorporated and myself. So let me finish building on this. Now, here he reconstructs or reinterprets, what the defendants are saying. You know what I mean, so that it can fit properly, in the context of the matter, the court. So the confusion seems to be over the phrase "never worked for," but the issue is not that he never performed work for ERS, but that rather he did so as an independent contractor and not as an employee. Mr. Lentz, who is the opposing attorney for the defendants, says correct. The court says, okay, do you understand that distinction, Mr. Smith? I says, I understand exactly what the defendants were getting at. My objection is simply that there is a case law on the fact that if in fact defendants are misclassifying me and they did so with the intent to have me denied unemployment, when in fact I am really an employee, and these 6 factors that go into distinguishing whether one is an employee or independent contractor, all 6 of the factors weigh against defendants, then that would be grounds for a retaliation claim. The court, okay, but that's separate than your interrogatory. You asked a question and they answered it. This is the court. This is what I'm dealing with. You know what I mean? Although he acknowledged that, you know, my legal work was above, way above average. It was on the level of a lawyer. You know, he still, you know, was trying to make it as if I didn't understand what was going on, or I didn't know what I was talking about. This here right here is another thing. I say, okay, so I guess I would like to ask, when the court looks onto these issues, is it the fact that the court has to wait until I, the plaintiff in this matter, comes forward with the argument, or would the court on its own see the issues, whether the issues are fraudulent or whether the issues are not fraudulent? Would the court on its own look at the matter and make a decision? The court says the law. That's a very good question, and it's a very broad question. But the bottom line answer is, if there are no undisputed material facts in the record when the case is over, you know, when discovery is over, that enable me to make the judgment as a matter of law at summary judgment stage, then yes, I do it. But if there are any disputed facts still hanging out there, material disputed facts, then that question will be left for the jury to decide. And I say, right, that's what I'm basically getting at, because what I'm understanding is that there can be no credibility determinations in the summary judgment manner. And basically it seems like all the defense is leaning on are issues of credibility, because this is what it's boiling down to. It's clear that there's no such thing as a 1099 employee. I'm quite sure the court understands that as well, because this is a serious issue of misclassification. And I was only wondering, because this is page 29 of the transcript that I just read, going on to page 30, because the court acted so quickly on the phone conference that I felt like I didn't, or I was not, my motion was not even considered as being an emergency as well. When the defense moved for their phone conference, I felt, when the court cut me off, Mr. Smith, there's a very easy answer to that. And my policies and procedures, which even though you're a pro se litigant, you should still read, okay? My policies and procedures with respect to discovery disputes, which is what this is instead of filing motions, simply write me a letter and I will convene a telephone conference to resolve the matter more expeditiously. Now, I'm going to stop at page 30, because what he's saying is, you know, in a nutshell, that his policies and practices override federal rules of civil procedure, because the federal rules of civil procedure, you know, give me the opportunity and the right to file a motion, which is what I did. And I filed my motion in plenty time before the phone conference was requested. This is why I'm trying to wonder why, when you got the motion and you reviewed it, and you said you had a determination, that you waited, that Judge Patriot waited until the phone conference, you know what I mean, and wanted to start making determinations, you know, but he wasn't really making a determination as to the motion I filed. He was making a determination, you know, based on the phone conference that was requested. You know, and again, like I said, you know, how can you overlook the remedy that I'm requesting when I requested it before the defendant, and it's my matter because I'm the one who filed the civil lawsuit? How can you overlook what I filed and immediately just grant a phone conference, you know, despite the fact that I filed my motion way before they requested the phone conference? So, you know, that was his way of allowing the defendants to get leverage over me. You know what I mean? And this is what I consistently was going through. You know what I mean? And it's crazy because I left his judgment or his memorandum. I left it home, so I don't have it, but I do have some of the judgment or the decision that he rendered.